someone who one would say needs no introduction. And then, of course, I go on to the introduction, because it is important that you know these things, because if we are to respect this organization, we have to respect the people who have helped find it. Howard Nations is a past president of the Bell-Eye Society, a past president of the Texas Trial Lawyers Association, a past president of the Southern Trial Lawyers Association, and a trustee of the American Jury Foundation. After 40 years of legal lecturing, and as a founder and former chair of the American Association for Justice National College of Advocacy, formerly known as Atlas National College of Advocacy, what we're doing here today, Mr. Nations is responsible for the vision of lecturing 40 years later to a room full of attorneys. We're probably about 160, 170, maybe even more, 200 in number, and each of us being rejuvenated by the experience of sharing our experiences with each other. And for that, we have Mr. Nations and so many others to thank. So without further ado, Mr. Howard Nations.
Summation. First of all, there has to be a symbiotic relationship between what I call the trilogy of persuasion, the three times that we get to address a jury directly. Summation begins with voir dire examination. You set it up on voir dire examination. Then you certainly set it up, absolutely set it up in the opening statement. And then you bring it home in summation, in the closing argument. And you carefully divide your time and how you use your closing argument between the first part of it and the last part of it. And we were talking about just about the issues about talking about money in those times, talking about money. When do you begin talking about money? What we're told today by the forensic psychologist is that now, before we start talking about specific large sums of money, we really need permission to do so, because there's skepticism on the part of the jurors against us and against our clients going in. And if we stand up and start trying to argue damages in voir dire or opening as we used to, it'll be seen as manipulation. So they have to understand, before we get to the issue of damages, they have to understand why damages are involved in this case at all. Why do they care how much damages there are? So you have to establish very clearly and unequivocally your liability before you start talking seriously about what your serious damages numbers are. We communicate with jurors in three ways: verbally, vocally, and non-verbally. And in our non-verbal communication, so much of that in summation is like this. I can't do it from here because I shouldn't be, if I'm going to be communicating with you, you shouldn't be having to look up at me. Communication is this. It's eyeball to eyeball. The approach to the jury is this. It's the open-handed approach. Look like anybody you know? This was the characterization as the theater teaches you. This is the Jesus approach. That's what they call it in the theater. You've opened yourself up. You have nothing to hide. And you're asking them to listen to what you have to say and become a part of it. So think about your nonverbal communication. Also, our friends from the theater teach us that this is not how you do a summation. You don't walk back and forth in front of a jury box looking at the floor. You also don't walk back and forth in front of a jury box looking at jurors. You make a contact. You finish a thought with that person, and then you can very subtly move on to the next person with your next thought, with your next point. And then you move, and you make absolutely sure that you're involving everyone in eye contact. But you don't do it like this. It's not, hi, I'm going to say a few words to you. Now it's your turn. Oh, hey, it's your turn. Let's talk for a while. It's moved. It's much more subtle, but you have to be you're not communicating with one person. You're communicating with all 12 all the time, but you're making eye contact with each person individually so that you get that communication working. I want to talk about defense themes and, and how we approach them. I began my career as a defense lawyer for 5 years. I worked with, I represented insurance companies and corporations, hospitals in medical negligence cases. And it was a wonderful education. That's in Houston, that's basically what we do. Most of the big-time plaintiffs' lawyers in Houston started out with the big law firms in Houston. We go over, train for 3 or 4 years there, and then move on, and then ask forgiveness for the rest of our lives. But what I learned there has been so incredibly valuable. I like to do a thing called Thematic Reversal. I like to determine what is the defendant's theme in this case, and then reverse it. Take it away from them on voir dire so they never get a chance to actually use it effectively. You can actually anchor your response to their theme. For example, if you've tried a traumatic brain injury case, what's called the mild brain injury, I've always thought a mild brain injury is one that happens to somebody else. But the mild brain injury case is the one that doesn't show up on any type of imaging. No x-ray, no MRI, no CAT scan. It just doesn't show up anywhere. It shows up in neuropsychological testing, and then eventually we know they exist because it shows up on autopsy. But so it's a neuropsychological workup. The defense theme is always, if you can't see it, it's not there. Can't see it on MRI, can't see it on CAT scan, can't see it on anything. If you can't see it, it's not there. So I like to reverse that theme on them and start in voir dire examination by talking to people on the jury about, I tell them, the defense theme in this case is, if you can't see it, it's not there. Now let's talk about some of the things that we can't see, but we know are there, that are pretty important to us. And people come up with things like oxygen. And then they get into things like faith and God and that. I don't get into that discussion. I just let them say it and move on. But the whole idea is you start them to thinking that there are other ways of doing things. And then you explain that the way this is handled medically is that right now, technology is still lagging behind injury. The reason we can't see it is not because it's not there, it's because technology has not come to that point yet. 30 years ago, we couldn't see a lot of things that we can see on MRIs today. They were there, we just couldn't see them. So you go with that. But then you have to determine, how do you see it? Well, you see it, you determine it through circumstantial evidence. So you talk to them about circumstantial evidence, and you're setting all this up you're setting up several things here. You're setting up this testimony of your neuropsychologist. So when he comes in and starts explaining the test that he's done and the results he got, they understand what that's all about. They understand that this is circumstantial evidence of a brain injury. So then you have to explain circumstantial evidence. What is circumstantial evidence? We usually ask on voir dire, again, you start it there. Remember Robinson Crusoe. He thinks he's alone on an island. What did he see that let him know he wasn't alone? He saw a footprint in the sand, a human footprint. He did not see the man. He did not see Friday for some time thereafter. But he saw a human footprint in the sand that was not his. That was circumstantial evidence of the presence of another human on the island. That's classic circumstantial evidence. Circumstantial evidence, when you're locked in that jury room, there are no windows, but if you leave at the end of the day and you see the streets are wet and there are drops of water on your windshield when you get in your car, you can reasonably assume from circumstantial evidence that it rained while you were in the jury room. That's circumstantial. That's the type of evidence that the court will tell you you may consider in arriving at the decision on a brain injury. And then you set that up. That sets up your closing argument for that. One of the defense tactics that we always like to use was who's being honest with you in this case. I remember when I tried my very first, and this I tell you this by way of caution, that we have to be careful. This is one of those reasons we don't put a lot of money up there on the board in the beginning or make outrageous claims. I tried my very first case from the defense, and the defense lawyer came in and just routinely said, I mean, this was back when the earth was first cooling, and it was $250,000 was a huge amount of money. And the plaintiff's lawyer, simple little auto accident case, and it was worth about $25,000. But he had pled for $250,000. So I told the jury, on my opening statement as defense lawyer, I said, let me tell you what this case is truly about. The plaintiff has said it's a $250,000 case. So let me tell you what it's really about. And I went to the board and I put up the special damages, just like you saw here. I put up special damages. There's this much in medical, there's 2 weeks lost time from work, there's this much property damage, there's this totals. And then if you're feeling very generous at the end of the day, let's say you're feeling extremely generous and you put $5,000 for general damages. The total, what this case is really about is $18,742.18. Now, I'm going to listen. Plaintiff's lawyer has told us. We heard him. It's a $250,000 case. So I'm going to listen along with all of you. And I'm going to listen for that other $232,000, the evidence of that other $232,000. And at the end, when I stand up to address you at the end of this case, the first question I'm going to ask you is this: who has been honest with you in this case? And of course, he doesn't have evidence of the other $232,000. I know it. He knows it. So at the end of the day, I stand up and ask that question. And who's being honest? And the numbers they're seeing on the board now are the same numbers they saw in the beginning. That's a tricky thing. So that's what can happen to you if you overstate your case. So when I went over to the defense side, I went to the side of truth and justice, I started thinking, okay, how can I reverse that? So you'd have to be sure you could do this in your state. But I took the pleading. You know, the insecure lawyers follow a form and they plead absolutely everything they can think of because they're afraid they'll miss something. So I still do this, and I love doing it. And that is, I talk about how the defense in this case has refused to accept personal responsibility, which is one of the biggest themes there is. He's refused to accept personal responsibility for their actions in this case. So it's going to be your job to place responsibility. They've refused to accept personal responsibility to the extent that they have filed with this court papers in which they claim this is the responsibility of the plaintiff. It's the responsibility of third persons unknown. It's the responsibility of, it's an act of God. An act of God. So I'm going to listen very carefully with you to this evidence about what act of God caused this intersection collision. What act of third persons caused this? So it just goes, and then of course, that's coming out of their pleadings. They can't really support it, and they end up with the same thing. At the end of the day, you've set up your summation for who's been honest with you in this case. And in the act of God, in serious injury cases, when they do plead the act of God, I'd have my, we did one not that long ago where we had a lady testify that what had gotten her through these devastating injuries was her faith in God, which is very true. She's a very religious lady. Her faith in God, which gave her the courage to go on. And her belief in the jury system that someday she would be able to have the additional medical and so forth that she needed. So I was able to say, there is an act of God in this case, but it wasn't in causing this tragedy. It was in giving this woman the strength to get through it. So that's what I call thematic reversal. And it's lots of fun. First thing you do is figure out what their theme is and then figure out how you can turn it against them. If it's a clear case of liability, where they can't. I love to, at the end of my closing, the opening part of my summation, I love to put up on the board the amount of my damages. We open fully, so we have to put all of our damages up in the first part of the closing argument. So I put the entire amount of the damages up, and it'll total $5,482,612. And then I'll say, now, ladies and gentlemen, this is what the evidence has supported. At least this amount. At least this amount. But if counsel disagrees with this number, I would like to have him come up and tell you right now, because I'm going to sit down now. Let him come up here and tell you right now what is the reasonable value that those of us in our society place on the life of a child. And then the defense lawyer has a dilemma. He can, if he goes up and tries to put any number on it, if he puts a low number on it, $250,000 for the death of a child. If he ignores it, then the way you've set it up, you can stand up and say, well, he obviously agrees with the number, because I said if he disagreed with it, he should put up a different number. You can only do that in clear liability. If it's not clear liability, they'll just walk up there and put a big zero and then go into a discussion of causation. How do you get into the discussion of damages? I don't talk about $10 million or $5 million or $100,000 in voir dire opening. I have a simple technique that I learned from a great lawyer named Pat Maloney in Texas. He would stand up and he would say, ladies and gentlemen, this case involves millions and millions of dollars. And would you be able to return a verdict if the evidence supports it? Can you return a verdict for millions and millions of dollars? And so Tommy Malone, I don't know if Tommy Malone is the best, most effective plaintiff's personal injury lawyer or not, but I'll tell you that the class he's in, it doesn't take long to call roll. Tommy called me. He was getting ready to go to a trial, and he says, you know what? I'd been familiar with the case all along. He said, I'm going to ask him for $25 million in this case. He said, I don't know what I should do, and I think it may be worth more. I said, well, why don't you do what Pat Maloney did? Just stand up and ask the jury, tell them it's about millions and millions of dollars, and at the end of the day, you can argue it in summation. So he did. He went for millions and millions of dollars, and the jury awarded $49 million in that case. So you got to leave yourself room for error by not making any errors. There's another defense they use of throwing everything up against the wall and see what sticks, and where they confuse, they muddy the water, and when we have the burden of proof, simplicity is our friend. So I tried a case against the Kodak Corporation, and they came in, and the judge, we were in federal court, and the juror asked the judge, said, do you have any idea how long this is going to last? So he said, I don't know. And he asked the lawyers, he said, how long is this going to last? And fortunately, he asked the defense lawyer first. They said, 15 days, Your Honor, 15 days of testimony. And he asked me, he said, Mr. Nations, I said, well, I have a very simple case, Your Honor. We can put it on in about 3 hours. So they had set up literally 16 feet of equipment was set up in the courtroom for all these demonstrations that Kodak was going to do with all this heavy-duty equipment. So anyway, I used one of my very favorite techniques. It's called a running metaphor. And this is what I use. When I know they're going to muddy the water, I set them up for this. But this doesn't just apply to closing. It applies across the board. You start using it in voir dire examination. But since I was in federal court, I didn't have any voir dire examination. So in this particular case, I said, what? Because the juror, the prospective juror who's trying to get off says, why is it going to take 15 days for them if he's only doing 3 hours? And he said, well, he was smart. He's trying to get off the jury. So I answered the question. In opening statement, I said, I'll answer the question. My theme was, this is a very simple case. We prove A, then B, then C. That's it. That's all we have to do. Now, the defense in this case is employing what is commonly referred to as the Octopus Defense. It's a standard technique of the defense. And of course, you can always throw in the old bromide about, if you have the law on your side, you argue the law. If you have the facts on your side, you argue the facts. If you have neither the law nor the facts on your side, you use the Octopus Defense. And the Octopus Defense is this. When an octopus is under attack, in order to extricate itself from its situation, it swims away and it squirts very dark black oil into the water in order to blind the eyes of those of its pursuer. The defense is using that defense in this case, the Octopus Defense, because what they're going to be doing, the reason they have all this equipment set up here, and the reason it's going to take them 15 days of testimony is because there's going to be 15 days of confusing evidence that they're going to try to bring for the simple purpose of squirting dark ink in your eyes. My job and your job is to keep your focus on A, then B, then C. That's it. Everything else is just oil in the water. So then as we go through, I put my client on the stand and we're testifying. It's a contract case. And he's testifying. I'm saying, okay, you heard the opening statement of defense. Now let's see if we can clear some of this oil out of the water. And ask him a question about it. And then on the cross-examination, use the same phrase in cross-examining their expert. And then in closing argument, after their defendant's argument, I was able to say, not since the Exxon Valdez has there been so much oil released in such pristine waters. Now, let me tell you, this was great. We obviously got a verdict or I wouldn't be talking about it, but after it was over, we're talking to the jurors. We only had 8 jurors. We were in federal court. So after it's over, the jurors stayed and talked to us. And they talked for a long time. And so they're asking questions of us, and then the defense lawyer, great defense lawyer, great guy, but he pops in there and he says, yes, but what about the foreperson of the jury was given an answer, and he says, yes, but what about this? And she said, oh, that's just oil in the water. So that was one of the first times that I actually could prove that this bullshit I tell you actually works. So the defense in malpractice cases always likes to, they always come up with a say for, they'll say, yeah, the standard of care that the plaintiff says is right. Yeah, that's standard of care. But there's not just one standard of care. There are several ways to do things. So then they bring in all their friends to testify. There's another standard of care, and it just happens to be the exact one that this defendant employed. So what I like to do, and I started as a defense lawyer, and I had the biggest mess because I had a doctor who was on duty. The other doctor who was supposed to be there was out that night. He didn't come in. So they brought this child in. I'm going to tell you this very quickly. They brought this child in, and the story was the child was brought in. They had symptoms. The doctor came in, looked at the child. Then they brought in a multiple injury accident case. This doctor had to run out and see this one. Then they come back and look at the child. Okay, do this test. Then they'd go out and do, and it was just a picture of total chaos. A picture of total chaos. And in the end, the doctor sent the child home. And the child went home overnight. They missed the diagnosis. The child went home overnight, and they brought him back the next day on an emergent basis, and the child died. So I'm looking at defending that. So the way I defended it very quickly was this. I put up on the board, I said, okay, what are the tests that you do, doctor, when you... what are the tests that are required when you presented these symptoms? A, purpose of A, did you do A? Yes, boom. What was the result of A? Negative. B, C, D, same thing. Did you do all these? Yes. Is that the standard of care? Yes. Now, did you do anything else? Yes. This hospital happened to have a new equipment that other hospitals did not have. Tell us what that is. What does it do? Did you do that? Yes. What was the result? Negative. Okay, so you've actually gone above the standard of care. Yes. Boom. They brought in a verdict for the defense, and which was probably the correct thing to do. I'm thinking when I get on the plaintiff side, how do I overcome that? And this is one of the most important things I can tell you, which is about the power of choice. The power of choice. You always, regardless of what type of case it is, one of the most powerful things you can do to set up your argument is to think in terms of how many different ways, how many different things could the plaintiff have done, or could the defendant have done, which would have avoided this result. Not just standard of care, but in an auto accident case, the defendant was driving too fast. The defendant chose to drive too fast. The defendant chose to drive in excess of the speed limit. Choices. The defendant could have driven more slowly. The defendant could have turned to the right to avoid the accident, the left to avoid, all sorts of things. So you put down in a product liability case, how many different designs were there? How many different ways could this have been done? In medical negligence, how many different ways, not necessarily standard of care, but what choices did the doctor make? And remember that doing nothing is a choice also. And so the more choices you can put up that the defendant was supposed to have done that would have avoided this accident, there gets to be an exacerbating effect from it. And the exacerbating effect really is important because that leads to increased damages. The next thing is a last thing I'll mention here, and then I want to do a very brief demonstration for you, is attribution. The attribution, two theories of attribution. The first is purposive attribution, and the other is reactive attribution. Purposive attribution says that if a jury decides that a person acted on purpose, not intentionally, but what's the difference? That they acted on purpose, okay? In other words, the defendant chose. They purposely decided to drive 70 in a 40-mile zone. They purposely decided to make that red light. They purposely decided to do whatever it was. If they acted on purpose, the jury will tend to not only find negligence, but punish, not punitive damages, but award more damages. On the other hand, the other side of purposive is reactive attribution. So if you can attribute the conduct of the defendant to reaction, they will actually even forgive, maybe even the negligent acts, if you were reacting to conduct from the other side. We are almost always in the position where the defendant acts and we react. So you want to stress to the jury that this is purposive conduct. They chose to do it this way. And the conduct, we ask you to examine closely the conduct of the plaintiff because they're going to anyway. And then ask you to review the conduct of the plaintiff in the context of they were reacting to what happened to the defendant, to what was caused by the defendant. So if you can set it up that way, you have a much better opportunity. Couple of things. One is have a reason for your number. The multiplier effect is wonderful. If you can find a low number and multiply it times the number, another number, that's excellent. Per diem arguments are excellent. Let me take the remaining time. They've asked me to do a particular closing argument, or a small portion of it. One of Aristotle's principles of persuasion was to execute the required level of emotion. It's harder today to execute the required level of emotion, because if you're not careful, the jury will think that we are simply manipulating them. So I've been asked to do a particular argument that blends executing the required level of emotion, ties it into, and hopefully moves seamlessly into a plea for punitive damages. And I'll just tell you, this is posted on my website. It's howardnations.com/publications. You go to the publications page. It's a Matthew Bender. There's a Matthew Bender analysis of this from their Summations book, and there's a tape under $1 Million Arguments. So if you don't have time to take notes or whatever, because I'm going to be moving through this pretty rapidly. But remember, you must have permission for an emotional argument. The goal of an emotional argument is to touch the life experiences of jurors so that they identify with the plaintiff. You're looking for commonality because they're going to make their decisions based upon life experience anyway. Listen to the metaphors, the rhetorical questions, the repetition of the theme, and the linking the emotion to the plea for punishment. Okay, this is just a small portion of an argument in the time remaining to me. It was the death of a child as a result of a product, and it was a defective product. We've already done a 40-minute closing argument. This is the responsive. This is the closing part of the closing argument in which I talk about the damages. I used to do this one from memory, but I like to say it's been a long time, but my memory is just fading rapidly. May it please the court, counsel, ladies and gentlemen of the jury. Now we talk of money. We talk of money because there is no magic. Is anyone so callous as to believe that if you as a jury had the power to bring young David Taylor through that courtroom door and bring him back down into the arms of his parents, that there would be talk of money? No. You would see only exultant joy as you watch these young parents emerge from the depths of despair into the heights of happiness. And you see that young family leave this courtroom as the happiest family on the face of the earth. But there is no money. There is no magic. There's only despair. There's no magic. There's only reality. There's no magic. So we talk of money. You know, magic exists only in the world of children, such as young David Taylor. The magic of each new day in David's life, his new challenges, his dreams, his fantasies. The magic of testing his God-given talents against those of his friends, particularly his young cousins. Hitting the ball as far, running as fast. The magic of his toys, his games, his Alaskan Husky snowball. The magic of every day, but especially birthdays and Christmas. Although there were only 7, and there will be no more. But what is this loss that you're called upon to measure? As I was thinking last night about what I could possibly say to help you measure the unbelievable loss that's being experienced by Karen and David, I was reminded of the prose that my mother had on her bedroom wall when I was a child. It was called, "What is a Boy?" I'd like to share a portion of that with you now. Between the innocence of babyhood and the dignity of manhood, we find the delightful creature called a boy. Boys come in assorted sizes, but all boys have the same creed: to enjoy every second of every minute of every hour of every day, and to protest with the noise, their only weapon, when the last minute is finished and mom and dad pack them off to bed at night. Boys are found everywhere, on top of, underneath, inside of, climbing on, emerging from, running around, jumping to. Mothers love them. Little girls hate them. Brothers and sisters tolerate them. And usually, heaven can protect them. A boy's a magical creature. You can lock him out of your workshop, but you can't lock him out of your heart. You can get him out of your study, but you can't get him out of your mind. You might as well give up. He's your captor, your jailer, your boss. A freckle-faced, pint-sized, cat-chasing bundle of noise. But when you come home at night with only the shattered pieces of your hopes and dreams, he can mend them all with those two magic words, "Hi, Dad." But David Sr. will never again hear those magic words, because the magic of young David's life ended on that fateful November day and was replaced by stark reality when an inevitable time bomb, which this defendant created and refused to recall, exploded and took with it the life of this young child and the hopes and dreams and aspirations of this young family. So that since there is no magic in our justice system, we speak of money. But we speak of money now because this defendant spoke of money 5 years ago in their corporate boardroom when they refused to recall this product. Why? Because a recall would have cost this corporation $4 million. So they refused to recall, and the inevitable tragedy occurred. Ladies and gentlemen, is that the standard of care and standard of safety that we will tolerate for our children in this great country? Or is it reprehensible corporate conduct which must not be allowed to occur again? That is your decision. That and the value to be placed on this young child's life. Now, the defendant warned you against sympathy for this family. We agree wholeheartedly. Don't look at this family with sympathy. Sympathy is like charity. It's demeaning. Believe me, they received sympathy at the funeral every time they looked into the faces of their friends and family. They received sympathy when they returned to the jobs and looked into the eyes of their coworkers. They received sympathy when they returned to their church services and looked into the eyes of their fellow parishioners. They've had enough sympathy to last 10 lifetimes. We're not here about sympathy. We're here about correcting a grave injustice. So in evaluating the damages in this case, don't look at the death of this young man. Look instead at the life that never will be. Since there is no magic, examine closely reality. The reality of the loss of David's society participating with his parents in various phases of their lives, the reality of the loss of his companionship, and the reality of experienced mental anguish every day of their lives. The reality by which you should measure the amount of money to be awarded in this case is that these young parents will never again share the daily joys, fears, hopes, and tears of David, this gift of God to this fine couple. Reality is that David lived only 7 years, 10% of his life expectancy. His life was like a mere preview of coming attractions. Reality is that these parents awaken every day of their lives to the realization that David is gone forever. Reality is that watching their friends, his friends and their young nephews, is a constant source of devastating mental anguish to this couple, as each night they think of that young life that never will be. The reality is they'll never know if David would have followed in his father's footsteps. High school merit scholar, college athlete, academic scholar, med school. Would he have followed in his grandfather's footsteps as a professional military man? Or would he have carved his own unique niche in life? We'll never know. But we do know that David's opportunity to live his own life is gone forever. In addition to David's loss, the reality of the parents' loss is that they'll never know those special moments that reward parents so beautifully. Karen will never again hear the 4 most beautiful words in the world. I love you, Mommy. They'll never share the competition of that first Little League game, the nervousness of the first date, the elation of high school graduation, or the maturing effect of college as they watch their young man grow up. They'll never experience that magic moment when young David walks in and says, "Hi, Mom. Hi, Dad. This is the girl I'm going to marry." David Sr. will never know that magic thrill of that moment when he picks up the phone and hears the most magical words of all. "Congratulations, Grandpa. It's a boy." The days of greatest joy for families, of family celebration in America, Mother's Day, Father's Day, birthdays, Thanksgiving, Christmas, are now days of mourning in the Taylor household. These are only a few of the endless litany of losses thrust upon these parents by the gamble of the corporate defendant. What is this child's life worth in our community? That determination is your role in the justice system, to write the final chapter of the book of this child's life. But ladies and gentlemen, before we close the books on young David Taylor's life, examine carefully another set of books in this case. Because as we speak here today, the life of young David Taylor is carried as a $4 million profit item on the books of this corporation. This corporation made the willful decision to gamble. It gambled the $4 million profit against the safety of the public. It gambled the $4 million profit on the judicial system of this great state. And it gambled the $4 million profit against the life of young David Taylor. We know that young David lost their treacherous gamble. The question is, did this defendant corporation that made this gamble win? That's your decision, Ms. Damdale. We say that if public safety is to be served and justice rendered, the corporation must not be allowed to win this horrendous gamble. That's why you're here. With your verdict, you have the opportunity and the responsibility to serve as the conscience of the community. First, to tell the Taylors that their family and their son, what they mean to this community, and the value that this community places on young David's life. And secondly, to tell this corporation if their gamble with the safety of this young child paid off. If your verdict is large enough, your voices will be heard in the entire industry with the message that we value human life infinitely more than we value the value of the profits of corporations. If your verdict is large enough, it will shine like a beacon in the sea of the treacherous seas of product liability and manufacturers' accountability, as we send the message that profit over safety will not be tolerated by the citizens who make up the juries of this country. So what is this child's life worth in our community? Is $4 million nearly enough? Council says $4 million is too much money. How much is $4 million in our society today? Ladies and gentlemen, we live in a society in which paint on canvas recently sold for $78 million. Why? Because it was the work of a master, Van Gogh. If paint on canvas is worth $78 million in our society because it's the work of a master, how can we even begin to make an award to compensate for the loss of the greatest creation of the greatest master of them all, God's creation of the human child. Is the life of David Taylor worth at least the $4 million we're seeking? The answer is that his life was priceless. We can't replace him. So we must talk of money. But again, when we talk of money, remember who talked of money first. Money was inserted into this scenario because the corporate board placed profits ahead of safety. So if you will use wisely your power, you can now serve as the conscience of the community and send the message that needs to be sent. How can you best serve your fellow citizens, get the attention of the board of directors, and render a full measure of justice to this fine family? First, by returning a verdict in the amount of $4 million in compensatory damages, and secondly, by an award of exemplary damages or punitive damages. Now, we have a simple method in this great state for what constitutes a fair, reasonable, exemplary damages award in a case like this. It's called treble damages. In this case, in addition to the $4 million in compensatory damage, the message that must go forth from this jury, which will be heard resoundingly in the boardroom, is conveyed by an exemplary damage award of $12 million. Corporations are motivated by profits. They operate on numbers. And if on a $4 million gamble, they lose $12 million additional dollars, then you're conversing fluently in the language of corporations. And that turns their profit-motivating minds to the production of safer products. For our examination, we told you that evidence would support $16 million. You know now what we knew then, that full justice demands both punishment and that an example be made of this defendant for the entire industry. You know now what we knew then, that the devastation visited upon this fine young couple cannot be compensated and justice fully served by less than $4 million in compensatory and $12 million in punitive damages. Ladies and gentlemen, I've carried the mantle of responsibility for this lawsuit on my shoulders for 4 years. And I'm now going to lift that mantle of responsibility and place it trustingly in your hands. And all we ask is that when you go home to your family and they say, "What did you do in court?" you can look them straight in the eye and say, "We helped make this country a safer place to live. We showed a family that their son was a very, very valuable member of this community, and we rendered full and complete justice." Thank you very much.